50s, the United States Supreme Court ruled that everyone, even if you can't afford a lawyer, has the right to a lawyer. That's why now I have a public defender's office. So if you can't afford a lawyer, that doesn't mean you go there and you're totally unable to defend yourself because you don't know the rules of the court. You don't know how to put together a defense. So public defender's office, the assistance of counsel. Amendment 8 is, relatively, it's not unimportant, but it's not something that is seen as often in court as, excessive bail shall not be required. People just bail out, and nor excessive fines imposed. Cruel and unusual punishment, that basically means torture, or a punishment disproportionate to the crime. For example, cutting off the hand of a thief, or sentencing someone who is, I talked about shoplifting a candy bar from Long's, person as a first offense, stealing that candy bar, 20-year sentence. I'm going to tell you about a cruel and unusual sentence. Many years ago, and this is a reported case, I'll say the person's name, is a fellow by the name of Mitchell Keto. He had, in 1981, he had no prior record. I think he was a student. He had in his possession, I think it was Valiums, a little over 50 Valiums in his possession. He wasn't selling them, he just had Valiums without a prescription. And he was found guilty of that offense. What do you think his penalty was? Take a guess. In the state of Hawaii. Caprice, you want to take a guess? Nope. Tiari, take a guess.
Like 10 years.
10 years! That's a long time, right?
1981, yeah.
You guys are tough. Well, it was 20 years, a mandatory 20 years. Yeah. And his lawyer argued that this sentence was cruel and unusual as applied. There are two kinds of cruel and unusual. One is the statute itself. If the law says, 20 years for promoting a harmful drug in the first degree, which is what I believe he was convicted of, it might not be cruel and unusual on the face of it, because if somebody's dealing with thousands of Valiums, right, in the black market, it's one thing. But here's a kid who just happened to have this. And so the lawyer argued cruel and unusual as applied to this particular individual. Judge Wendell Huddy agreed and said, this is ridiculous, that this 20-year sentence. Reduced it to, gave him, I think probation would, and I don't even know if he had any time. The Hawaii Supreme Court reversed and said, no, that's what the law says. It's not cruel and unusual as applied. Reinstate the sentence. He gave him 20 years. He had to on remand to the circuit court. The parole board, of course, paroled him, I think, within 6 months, so he was out. But that's what cruel and unusual punishments have to do with. And finally, the 14th Amendment, due process and equal protection. This is equally applicable, and particularly applicable to civil matters, right? Due process really means that the law has to respect the system in which the person is prosecuted. You can't just rush people off to prison. You have to give them all their rights, and all the rights that are incorporated into the first 10 amendments, the Bill of Rights. Also, equal protection. You have as much right to protection of the law as Ashley does, Caprice does, or Valerie does. Everyone is equal under the law, regardless of your race, creed, color, age, sex, etc. So that's important. The 14th Amendment due process equal protection clause was especially important in an America where blacks were being discriminated against. Very important amendment for their ability to have access to a fair and impartial court. And even with that 14th Amendment, most of them did not anyway. So in the history of our country, unfortunately, things have changed, fortunately. That's pretty much about I'm not going to talk about the Hawaii State Constitution, but you see Article 1 has due process, equal protection, searches and seizures, and Section 7 of that article, and so forth. Very, very similar. The rules of penal procedure, I am not going to talk about that as well. I'm just going to leave this for you to look at. But Rule 12 has to do with pretrial motions. Rule 16 is discovery. Discovery in the criminal context is really different from civil discovery. Civil discovery, you have interrogatories, right? You have depositions, things like that. We don't do that. There is a provision for a deposition, and in fact, a woman who's working on a case with me said, why don't we depose this person? Well, you can't depose a person unless they're not available for trial. We don't depose in the state of Hawaii. Some states do. Arizona, they do depose. There's no written questions, interrogatories to the prosecution to find out what the case is. The discovery happens to be the reports of the police or the, state agents, law enforcement agents. They compile a report and they provide it to the defense. We have very liberal discovery in the state of Hawaii compared to the federal government. You can have a huge case. You can have as I did, you can have, a conspiracy, a tax fraud, public corruption case with thousands of pages of documents and not get those documents until just before the trial. It's kind of weird rule that they have. It's very, very hard to prepare from an informed basis in the federal system, but that's the way it works there. State of Hawaii is also better in another way. Has nothing to do with the materials I've given you, but I just thought I'd let you know. You might find this interesting. In the federal system, let me start with the state system. If you're charged with a misdemeanor or petty misdemeanor, misdemeanor means a crime that is punishable by no greater than 1 year in jail, right? Petty misdemeanor, no greater than 6 months. Most of them are 30 days. Then the officer, the police officer on the beat, can question you, it has to give you your rights, but can question you about the offense. Trespassing the school property, let's say, or the shoplifting case I told you about. Once it's a felony, they don't question you. They bring you down to the police station, usually the main station, but not always. Sometimes it can be like Pearl City Station. And a detective, which is a police sergeant or higher, who is a plainclothesman, plainclotheswoman for that matter, will then interrogate you, give you your rights, and everything is recorded. The tape recorder goes on. All right, Ms. Falanico, you understand that you are in the custody or the presence of the Honolulu Police Department at the Pearl City Station. Yes. All right. Yeah. Now I'm going to ask you about, the theft of an automobile, a 1995, Toyota Camry. But before I do, I'm going to tell you that you have certain rights. You have the right to remain silent, and they have a form you check off. If you understand, Yes. Check. You have the right to remain silent. Anything you say can be used against you. Understand? Yes. Check it off. It takes a while. It takes several pages. Do you want an attorney now? Anytime you want to stop, you let me know. Check it off initially. That's called the HBD 81 form. The feds never record anything. Never record anything. The FBI never records a statement. The drug enforcement agents never record a statement. The Navy Criminal Investigation Section never records a statement. You might be asking yourselves, why not?
Not required. Not required.
Well, it's not required, but you would think that it would make for a much accurate statement, wouldn't you? Mm-hmm. Now, I have a theory as to why that is so, but now you're going to see my bias, because I used to be a prosecutor, now I'm a defense lawyer. I think the prosecution, federal agents, want to shape the statement the way they want it to come out, unfortunately. It's a very sad commentary, but I think it's true. And I've seen it happen over and over and over again. And I've won cases because it happened. An example was I had a bunch of people from Waianae who were victims of a scam, pyramid scheme, but they were being suspects. And I allowed them to be interviewed by the FBI. They came to my office, put them in a conference room, and there were a bunch of them. And I said, well, before you interview them, I'm going to allow you to interview them, but I want you to record it. They said, no, we don't record it. I said, well, you're not required not to record. So he said, well, it's not our policy to record. I said, fine. Then I will record it. Otherwise, you don't interview them. So I turned on my tape recorder. at the conclusion of the interview, they said, "Can we have a copy of your tape?" Sure you can. And they never were charged because they were victims of this crime, not perpetrators. But, you know, I don't know why they do it. The Honolulu Police Department, I'm not talking about what happens in the street. I'm not talking what happens at some of the nightclubs where, you know, people get roughed up and you wonder why. I'm talking about the detectives, I think, are usually very, very good. One thing for sure, they record it. So if the person says, "I was driving a 2005 white Toyota Camry," it's in the recording. If anybody says, if the defendant says, or the suspect says, "I didn't say that. I said I was driving a blue 2006 Ford." Turn on the recording. "I was driving a white Toyota Camry." The police are correct. "I was driving a blue Ford." The suspect is correct. The feds will write that down. And I use that example because I've had cases where the car didn't make a difference. Well, my client would say, "Yeah, I didn't say that. That's not the car I have." You know, besides other things that are important that were wrong. And sure enough, you know, the agent would say, "Well, you know, that's what I thought he said when I wrote down my notes." But they're writing notes. You know, so you have a few pages of notes. How many people are completely accurate taking notes? No one is, especially when. So anyway, I don't know why I'm ending with that note, but that's pretty much where we're at. I like what I'm doing. I didn't cover as much comprehensively as I usually do, but I wanted to talk about Dudley versus Stevens. So thank you for paying attention. Nobody fell asleep, which is great. Better than the juries that I've had lately. So thank you very much. And if you have any questions, just call me. My number is 545-5000. If you have any questions about criminal law, please feel free to call me. Okay? Okay, you're welcome.
Thank you.
You're most welcome.